Yes, good afternoon. Larry Marshall, Bermudians Against the Draft. I've been asked by Bernews to respond to a statement issued by the chairperson of the Defense Exemption Tribunal, and I'll first read the statement and then give Bermudians Against the Draft's response. Wednesday, June 1st, 2011. During the course of that hearing, the applicant's conduct became abusive towards the tribunal, and consequently the chair was forced to adjourn the proceedings abruptly. As a result, there has been no determination made on the application of these persons as to their conscientious objector status. The hearing has not recommenced, and there has been no further progress in this matter at this date. Okay, first of all, let me say that Ms. Mapp states the applicants, meaning all three, that their conduct became abusive. That's not true. Lamont's conduct never became abusive, and the recording made at the hearing will substantiate that. Unlike our recent Court of Appeal hearing, this tribunal actually had a recording from which we can get our transcripts. Okay, again, Lamont's behavior was not abusive. Secondly, Ms. Mapp conveniently omits what precipitated the heated confrontation. And that was what everybody in the room perceived to be a threat made by Mr. William Medeiros toward Lamont. And during his going back and forth with Lamont, it got heated, and he put his fingers together and suggested that Lamont was coming close to crossing a line. Everybody in that room, including Ms. Mapp and her fellow panelist, Victoria Pierman, were shocked that he could make that statement. Everybody interpreted that as a veiled threat. Okay? Now, at that point, my oldest son, Larry Jr., erupted, and it went from there. And then there were words exchanged between Larry and the tribunal members, and then Jamal jumped in. At no point did Lamont participate in that heated debate. As a matter of fact, when things settled down, I asked Lamont to question Mr. Medeiros as to what exactly did he mean when he put his fingers together like that and said, "You're coming very close to crossing a line." At that point, Ms. Mapp decided to adjourn the proceedings. So to suggest that the proceedings were adjourned because, you know, everything had gone haywire, things had calmed down. But I think at that point she realized that Mr. Medeiros had made an egregious mistake when he threatened Lamont. Thirdly, for the record, Mr. Medeiros is a former major in the Bermuda Regiment, and it has always been our contention that you cannot have a fair, impartial, and objective tribunal if one of the three people sitting on that tribunal, they are I mean, you're talking about this guy, William Medeiros. He was second in command. Most of his friends are in the regiment. Do you really think that he can give an impartial judgment regarding Lamont? Now, his behavior was deplorable, and that precipitated the confrontation. It got to the point where he felt that he was very condescending and arrogant and demeaning to Lamont. He felt like he's still in the regiment, and he can treat Lamont like Lamont's still in the regiment. And that's you know, where everything went haywire. And again, he should have never been on that tribunal. So now we had a situation where it was calm, and you know, we decided to move on. Ms. Mapp decided that, well, she's going to adjourn it. And I find it very interesting that this hearing took place June 1st, 2011. Here we are, January, what, 20th? 2012, what, 7-8 months later. And she's just talking about their status as conscientious objectors hasn't been determined, stating that it has not recommenced and there has been no further progress in this matter at this date. Okay, who's the onus on? And I don't want to get into nitpicking or whatever, but wouldn't the onus be on the chairperson to say, listen, things are out of hand, can your members give an undertaking that they'll try to control their emotions and we can get this thing sorted out? 8 months have elapsed. And I mean, what is it mere coincidence that Lamont's threatened with arrest and the government has instructed them to come out with a statement? And I think that this thing needs to be put in perspective. This is a very serious human rights issue, and what the government is doing is playing this technicality game. We were given leave by Justice Ian Carewley in July 2010 to proceed to Supreme Court and have this matter dealt with. Yet the government lawyer constantly talks about, well, they haven't been before the tribunal. It's purely a technical argument. And what I would like people to just step back from all the emotion, and I know that I'm perhaps one of the biggest culprits when it comes to emotionalism over this issue. Step back. Ask yourself the question, are Larry and Lamont Marshall and Jamal Hartman conscientious objectors? Because if they're not, then there is no such thing as a conscientious objector, because they have spent the last 6 years of their life fighting for their right to choose whether or not they want to go into the Bermuda Regiment. And I think that the time has to come where people appreciate that the tribunal, and that's ironically one of our points that we're making before the courts, is that the tribunal is not impartial, it is not objective, because of a number of reasons, but primarily, I get back to the point that I made, and I stress that it should never have a major from the Bermuda Regiment sitting on that panel. And every tribunal that I've been to has a former major sitting on the tribunal. And that we believe to be wrong. So I think I would just hope that would clarify our position in regards to what actually transpired, and also make the point that during the Supreme Court hearing, as well as the Court of Appeal hearing, which the latter did not have any recording, so I can't prove what I'm saying, but at no point in time did the government's lawyer, Ms. Shakira Deal, at no point in time did she ever argue that Larry Marshall Jr., Lamont Marshall, and Jamal Hartman were not conscientious objectors. She never made that argument. The only argument Ms. Deal made was the fact that, they haven't appeared before the tribunal. And in essence, what just trying to do is have the judges rule against us on a technicality. And I think that's a sad reflection on our government when an issue of this importance, when you're talking about human rights violations and the human rights of these young men, when you're talking about people that honestly believe conscription is wrong and they shouldn't be a part of that regiment, for the government to go to court on a technicality is reprehensible. And that's our position, Bermudians Against the Draft. Thank you.
Moving forward, what is BAD looking for?
What we're looking for in the immediate short term is the right not to be harassed by the Bermuda Regiment while this case is before the courts. Now, our lawyer, Eugene Johnston, is presently out of Ireland, and I believe he returns on the 26th of January. So, really, we have no legal representation because, until he comes back, although I have spoken to one lawyer who has generously offered to fill in an emergency situation. Our position, like that's legally, we go to the Court of Appeal on March 2012 to request leave. But we also anticipate on filing a judicial review to look at what we consider to be the illegality and procedural impropriety of that Court of Appeal hearing on November 7, 2011, because no recording was made in a court that is described, that is defined by law as a superior court of record, which means they have to keep records. As a result of them not making a recording, and they have what they call a court smart recording system there for that specific purpose, they did not make a recording, and these young men, we have no transcripts going to the Privy Council. And that is unbelievable, that the highest court in this land, the Court of Appeal, would conduct itself without the benefit of a recording, without the benefit of these transcripts. And in my opinion, what took place in that courtroom is unacceptable, and we need to address it. Our government, our Attorney General needs to look into why there were no transcripts made, no recordings made, and also there's at least 3 other individuals who did not have recordings made, and we believe that that is in violation of several acts of Parliament, as well as constitutional rights that plaintiffs have before the court.
Thank you for your time.
Thank you, sir.